Assalamualaikum. My name is Nohawani binti Fauzi, matrix number 272981. I will explain about the superior courts. Superior courts consist of the Court of Appeal, the Federal Court, and the High Court, which include the High Court of Malaya and the High Court of Sabah and Sarawak. What are the functions of the superior courts? Superior courts have the authority referred to as jurisdiction to ensure that everyone, including the executive, states, parliament, public authorities, and private organizations, follow the constitution and all laws. The superior courts can, first, determine what terms in the constitution or any law mean when there is a conflict. Second, announce that a law is against the constitution and therefore void, and it does not have to be obeyed. Third, determine whether any action by the executive or any state is legitimate through judicial review. Fourth, impose criminal law. And lastly, fix dispute between parties, between an individual and the executive, between the federal government and a state, and so on. However, the Superior Court's ability to decide these cases is limited. Referred to judicial power restriction. Prior to March 1988, the Superior Court's judicial jurisdiction was derived directly from the Constitution, as the Constitution stated that the judicial power of the Federation is held in the High Courts. This meant that the courts could examine all laws to see if they agreed to the Constitution and determine whether or not any activity was legal. Parliament modified the Constitution in March 1988, removing the statement that the Federation judicial power is concentrated in the High Courts and replacing it with a statement that the High Courts only have the jurisdiction granted to them by Parliament under federal law. Some argue that the amendment limits the court's power because they may now only look into laws and activities that Parliament permits them to look into. Others, on the other hand, says that the 1988 amendment is useless since the judicial power granted to the courts under the Constitution is part of the Constitution core structure and cannot be withdrawn by parliamentary change.
In any civil cause or matter, the Court of Appeal also has the jurisdiction to hear and determine an appeal from any judgment or order of any High Court in any civil cause or matter, whether made in exercise of its original or its appellate jurisdiction, subject to any written law regulating the terms and conditions upon which such appeal are brought. Notwithstanding, there are matters which are non-appealable to the Court of Appeal. Under Section 68 of the Courts of Judicature Act 1964, Act 91, the list of cases involved of any followings. First, the amount of the subject matter of the claim is less than Rm 250,000. Second is where is the judgment or order is made by concerned or parties. Third is where the judgment or order relates to cause only which by law are left to discretion of the court. And the last one is where any written law for the time being enforce the judgment of the High Court is expressly declared to the final. So that is for me. Thank you. Under Article 121(1)(b), there shall be a court which shall be known as the Mahkamah Rayuan, Court of an Appeal, and shall have its principal registry at such place as the Yang di-Pertuan Agong may determine, and the Court of Appeal shall have following jurisdiction, that is to say, A is a jurisdiction to determine appeal from the decision of a High Court given by a registrator or other officer of the court and applicable under federal law to a judge of the court. B. Such other jurisdiction as may be conferred by or under federal law. In any civil cause or matter, the Court of Appeal also has the jurisdiction to hear and determine an appeal from any judgment or order of any High Court in any civil cause or matter, whether made in exercise of its original or its appellate jurisdiction, subject to any written law regulating the terms and conditions upon which such appeal are brought. Notwithstanding, there are matters which are non-appealable to the Court of Appeal. Under Section 68 of the Courts of Judicature Act 1964, Act 91, the list of cases involved of any followings. First, the amount of the subject matter of the claim is less than Rm 250,000. Second is where is the judgment or order is made by concerned or parties. Third is where the judgment or order relates to costs only which by law are left to discretion of the court. And the last one is where any written law for the time being enforce the judgment of the High Court is expressly declared to the final. So that is for me. Thank you.
Assalamualaikum and selamat sejahtera. My name is Nur Shakira binti Muhammad and my metric number is 270887. I will discuss about the Federal Court. Okay. The Federal Court of Malaysia is the highest judicial authority and the final court of appeal in Malaysia. Its decisions bind all the court below. The Federal Court consists of President's style as the Chief Justice. It's formally called the Lord President, the President of the Court of Appeal. The two Chief Judges of the highest court are in Malaya, in Sabah and Sarawak, and presently 6 Federal Court judges. The Federal Court is here 3 judges or such a greater and even number of judges as the Chief Justice may determine in the same particular cases. Okay, next, the Federal Court has the exclusive jurisdiction to determine. First, all civil and criminal appeals from the Court of Appeal. In civil appeals, a litigant may be appealed on a point of law in the rejection or admission of the evidence in lower court. In criminal cases, an appeal may be against ethical or conviction or against sentences on point of law or fact. Second, dispute and any question between states or between the Federation and any states. It stated in Article 1 to 8 of Federal Constitutions. And third, any constitutional question which have arisen in the proceedings of the High Court but referred to the Federal Court decision. Last but not least, the Yang di-Pertuan Agong may refer the Federal Court for its opinion or any question as the effect of any provision of this Constitution which has arisen or appears likely to arise, and the Federal Court shall pronounce in the open court its opinion on any question so referred to it. That's all from me. Thank you.
My name is Nur Fatin Hanisa 270551. I will continue the topic about High Court. The High Courts in Malaysia are the third highest courts in the hierarchy of courts after the Federal Courts and the Courts of Appeal. Article 1 to 1 of Federal Constitution provides that there shall be 2 High Courts of coordinate jurisdiction, which is the High Courts in Malaya and the High Courts in Sabah and Sarawak. The 2 High Courts in Malaysia have general supervisory and revisionary jurisdiction over all the subordinate courts and jurisdiction to hear appeals from the subordinate courts in criminal and civil matters. The High Courts have unlimited jurisdiction in all criminal matters other than matters involving Islamic law. In criminal jurisdiction, the High Court may hear all matters but generally confines itself to offences on which the magistrates and the sessions courts have no jurisdiction. For example, offences which carry the death penalty. Last but not least, cases are heard by a single judge in a High Court or by a judicial commissioner. While High Court's judges enjoy security of tenure, judicial commissioners are appointed for a term of 2 years and do not enjoy similar protection under the Constitution.
In conclusion, the Federal Court, Court of Appeal and High Courts are superior courts. The superior courts are established under Article 1 to 1 of the Federal Constitution. The jurisdiction of the Federal Court and the Court of Appeal is defined by both the Federal Constitution and the Courts of Judicature Act 1964, while the High Courts is defined only by the Courts of Judicature Act 1964 and superior courts have unlimited jurisdiction.